Hello. Hello, everyone. My name is Letizia Roman, and together with my colleagues Giulia Pasquali, Anette Sonnbäck, and Yasmina Alui, I would like to thank you for coming today. We are looking forward to talking to you about the Europe-wide net for security cooperation um, and analyze how this will be impacted by Brexit and the newly reached EU-UK trade and cooperation agreement. I would like to start by underlining how intrinsically difficult it is to find an agreement in the field of foreign affairs, and especially on sensitive matters such as security and defense. The European context has been and still is a victim of perverse phenomena such as organized crime, terrorism, and ever-growing polarization. In this context, despite the challenges of reaching a common ground, there is a mutual interest to continue the UK-EU collaboration in matters belonging to the internal security realm in Europe. This fact was especially highlighted and proved during the negotiation process. In the past, the UK has had a leading role in contributing to the internal security in the EU. So naturally, it was very important to establish a close relationship in that sector, even in a post-Brexit context. Former Europol Chief of Staff Brian Donald explained in 2016 that around 40% of Europol's cases involved UK law enforcement. The UK is a major player and provider of intelligence resources, and thanks to the EU's information sharing regime, it has helped tackle serious threats such as organized crime, terrorism, and cybersecurity. This is exactly why it was crucial for both the EU and UK to reach an agreement that would continue and shape the future cooperation in this area. Ceasing or ending cooperation would only have detrimental effects. Mostly because with the rise of cross-border crime, cooperation between law enforcement agencies is invaluable. As such, the lack of cooperation would result in a capability gap, because the alternatives would inevitably lead to a reduction in available information, and it would be overall slower and more complex. Luckily, the adversity was avoided. On the 21st of December, both reached an agreement on the terms of the UK's future cooperation with the European Union after much uncertainty. That included a pillar on citizen security, and it incorporated several security tools such as the passenger name records and PRUM, as well as Europol and Eurojust. Having reached an agreement is crucial and provides several insights. To begin with, having an agreement that includes cooperation in the field of internal security and its consequently vulnerabilities is an acknowledgement that contemporary threats know no borders. In order to fight international crime, a toolkit enabling cooperation between law enforcement agencies through the access and exchange of information leads to a more effective, centralized, and swift response. Swift data exchange and access is the key for identifying and responding to threats around Europe. On top of that, such cooperation has proven to pave the way and enable the work of law enforcement agencies in their joint attempts to tackle criminal activity. Intelligence and information sharing tools have furthermore proven to be vital for identifying and responding to possible threats around Europe. In that sense, Europol is the EU's law enforcement agency, helping the EU's member countries to fight serious international crime and terrorism. Europol is the sole agency that has adapted time and time again, proven its flexibility in dealing with older and newer threats. Given the context and nature of cooperation, we assessed Europol as able to coordinate information exchange, placing it at the core of cooperation between the UK and the EU in internal security, as an overarching umbrella agency that not only has proven to be effective, but maintains its relevance over and over and over again. With this in mind, I would like to present the agenda for the following presentation. My colleague Giulia will delve into the focus of our research, which is Europol and its tools for information exchange and intelligence activities. She will then flesh out some of the challenges for EU-UK intelligence and information sharing posed by Brexit and by the concluded agreement. After that, she will outline the two policy options that we thought were the most feasible in the future, namely a tailor-made agreement and or a hybrid model. She will wrap up the session by presenting the main policy recommendations and the reasoning behind our choice, also in the light of the Trade and Cooperation Agreement, which was concluded over the holidays. Shortly after, we will open the floor for the Q&A session. Thank you so much for your attention, and it is my pleasure to give the floor to my colleague, Giulia. Giulia, you have the floor.
Hi everyone. Thank you, Letizia, for introducing this very challenging topic. So let's delve into the heart of our policy paper by talking a bit about the Europol. So as I'm sure you all know, Europol has the important task of supporting member states in tackling internal security threats, such as terrorism, organized crime, and cyber threats. What is key to stress here, I think, is that the UK is one of the member states that used the Europol EU agency the most in the past. For example, as Letizia mentioned, 40% of Europol's cases involved UK law enforcement. Moreover, the UK has been one of the main contributors to the agency's crime intelligence analysis and provided extensive data to Europol's analysis projects. So in particular, Europol has a crucial analytical role as it facilitates intelligence-led investigations. Under this framework, two central bodies of intelligence sharing are the Europol Information System, EIS, and the Europol Secure Information Exchange Network, Siena. The former is Europol's central database, storing information related to criminal activities, whereas the latter ensures data protection and confidentiality. In other words, it ensures secure information exchange in compliance with all legal requirements of different member states. The EIS is of particular importance as countries can use the system to identify connections to different leads in ongoing investigations, which is a great support for law enforcement agencies across the EU and has enabled the identification and disruption of cross-border criminal networks across Europe. Siena, on the other hand, with its flexibility and fast-growing integration of crucial law enforcement units and initiatives, has proven essential for safe information and intelligence sharing among member states. Here too, the UK has had a record of positive contributions. Data, in fact, placed the country as the highest contributor to serious crime intelligence analysis and the second highest contributor overall. Then, last but not least, we have the European Cybercrime Centre, also known as EC3, which, as the name suggests, is tasked with supporting member states in their efforts to tackle cybercrime, especially by developing operational and analytical tools for cross-border investigations. Here too, the UK has considerably benefited from the various services provided by the EC3 and successfully tackled cybersecurity threats. EC3's cybercrime activities are furthermore another important illustration of the central role of Europol as an informal intelligence agency with vast expertise, enabling the work of law enforcement throughout the EU. So this brings us to the challenge that we were confronted to when writing our policy paper, that is, what are the effects of Brexit on all this? And you can see this on this current slide. the one before, thank you. Sorry. So I'm going to talk a bit about the Trade and Cooperation Agreement, so also known as TCA, that has been agreed in December. So both the EU and the UK understood the importance of strong cooperation in internal security matters. And in fact, in the Trade and Cooperation Agreement is mentioned that the UK should continue to collaborate with Europol as a third country. The framework of cooperation that they have agreed is therefore an important step towards continued security cooperation, but it is clear that the parties will not enjoy the same benefits as before, which will lead to reduced capabilities to deal with security challenges in Europe. So this type of agreement, this form of cooperation concluded in the agreement resembles a third country operational agreement, but there are certain modifications. So operational cooperation with Europol as a third country is a common form of partnership and is currently being used by 17 countries, including Norway, Switzerland, Canada, and the US. This type of agreement allows for exchange of general intelligence and strategic information, as well as the exchange of personal data regarding individual criminal investigations. Yet, despite the existence of an agreement in this area, the UK has lost many of its past privileges. In regard to intelligence and information sharing, for instance, it will not be able to participate in units like the EC3 that I just mentioned, or benefit from their intelligence work. But one of the biggest losses, it's also its loss of direct access to EU databases, including the EIS. So in fact, while the agreement enables the exchange of personal data regarding individual criminal investigations, it is connected to extensive conditions. Most problematic is that the UK must now request data from Europol, which will increase the time it takes to receive crucial information, which is greatly damaging to an investigation where speed is key. One alternative for the UK would be to engage with Interpol, but this will not be able to replace Europol's information sharing tools, since the data is less reliable and the members are more hesitant to provide large quantities of data due to the lack of trust that arises with 194 member countries. Moreover, the UK will no longer be able to directly submit data to the system either. So it works both ways, basically. So this will be damaging to the EU that has benefited from their extensive data contribution during their membership. On top of that, even though the agreement allows for continued access to Siena, which is key to secure data transfer, this will not be enough if it does not allow for extensive access and data transfer on the UK's part. Another important loss for both parties is the UK's involvement in the leadership of the agency and its involvement in the creation of cooperative systems for law enforcement activities. By these I mean that the UK will now be excluded from the management board and will no longer have management board voting rights. It should, however, be noted that the UK representatives will have the right to participate in meetings of heads of Europol national units, which could include a formal participation of the British designated authorities to discuss, shape, and contribute to policy issues and matters of common interest under the umbrella of the Europol. And the UK will also be able to participate in operational analysis projects, albeit not lead operational projects. So these two last points are the main provisions that actually go farther than a traditional third country agreement. So I previously mentioned that the UK has an agreement which it's similar to a third country agreement, but it's not. So it goes a bit farther. And so these last 2 points expand on a third country agreement. But this will, we think that this will not be enough to, enable extensive security cooperation and information sharing possibilities between the UK and the EU. And so this, the question is, why wasn't there in December a better agreement? So, of course, there are many aspects that need to be considered. An important one is regulatory compliance with the EU data protection and privacy laws. And surely, there were time constraints, and we all could see. And again, though, while researching, we did come to the conclusion that a more comprehensive agreement in this field can be struck. and that hopefully there will be the necessary political will to do so. Yeah, hopefully not too far away in the future. So yeah, this brings me to the two options that are legally available for the EU and the UK in this field. So there are two possible agreements that could be reached. The first one is would be a tailor-made agreement, similar to the one that the EU has with Denmark currently. So this type of agreement would go deeper than what has been currently agreed, in the sense that it would enhance the UK's competencies and participation in Europol's activities. It would enable the UK to have indirect access to the EIS through UK representatives in Europol available 24/7, thereby providing much greater possibilities for quick information sharing than with the request-based system that the current agreement would entail. One important difference between the provisions in the TCA and this tailor-made agreement would also be the right of a British representative to be involved into meetings with Europol Management Board, albeit from the position of an observer with no right to vote. This option was not included in the TCA and would be an important addition in order for the parties to benefit further from each other's insights and expertise. There are, however, some relevant downsides to having a tailor-made operational agreement. First, if it was to be modeled on the Danish example, the UK would have to recognize the jurisdiction of the European Court of Justice, as provided for in Article 48 of the Europol regulation. This is something that the UK has repeatedly objected to. I mean, in the end, is the whole point of the take back control sort of line of argument. Secondly, the access to sensitive data will be heavily regulated, which means that unlike the clearance level that the UK had prior to Brexit, there will still be a strong shift in the paradigm under which the UK will operate. And finally, the UK will most likely inherit the status of an observer with no decision-making power within the EU agency, despite necessary concessions such as ECJ oversight. Then the second option would be a hybrid model, which is an attempt to find a solution enabling UK's wider access to Europol and avoid ECJ oversight. So apart from its participation in operational meetings, analysis projects, and invitation to board meetings, data access to databases remains a key factor for security cooperation, as it enables more extensive information and intelligence sharing capabilities. The UK has long argued for the goal of maintaining direct access to the EIS. And based on our analysis, we agree that this could enhance the effectiveness of the work of law enforcement agencies in both the EU and the UK. Without ECJ oversight, however, the EU would have to ensure data protection and a compliance with EU standards in other ways. Data protection is indeed one of the EU's main concerns in the areas of continued intelligence and information sharing, and thereby main hindrance to a more extensive information sharing agreement between the parties. We would argue that the UK could instead be subject to an extensive adequacy decision unique to the British case. As you might know, an adequacy decision is a mechanism by which the EU determines if a non-EU country has an adequate level of data protection. So this would be connected to terms in a specific agreement, either a standalone agreement between the UK and Europol, or as part of a more extensive security agreement. This decision would be granted for an unlimited period of time, but as with all adequacy decisions, it could be revoked when deemed necessary. This might offer an incentive to the UK to proceed with revisions of its data protection and privacy regime where necessary, as it would otherwise lose access to Europol. It is true that this type of hybrid agreement would set a precedent and would imply compromises on both sides. This in turn would result in a complex negotiation process involving technical details and precarious legal issues, but it is nevertheless the most beneficial option in terms of fighting capabilities, as it would answer to the main concerns of both parties, as well as that of law enforcement agencies in the UK and beyond. Then another main downside will be the complexity of such negotiation, which could indeed take years to conclude. But thanks to the TCA currently in place, the countries and their law enforcement agencies will, however, keep cooperation tools in place and can therefore work as an interim agreement until a decision has been reached on this hybrid model. and would thereby allow for cooperation to continue without extensive disruption. Albeit in a different capacity, obviously. Which brings me to our final recommendation. So in our research, we recommend that the EU and the UK strive towards realizing our second policy option, where the UK would have direct access to Europol databases, such as the EIS, and have a greater role in the agency. So this would be the hybrid model option. So first, we would recommend that the parties take up negotiations for a separate security treaty where Europol cooperation and information sharing is included, if not even actually a specific treaty for UK Europol cooperation. Especially in the following months, now that the pressure to find a comprehensive deal is sort of settled, and with the hope that the pandemic will slowly cease to be at the center stage of policymaking, we think that there is momentum for the EU and the UK to specifically focus on security cooperation in a less politicized environment where the parties could be open to further concessions. One important next step that the UK is already awaiting is a standard adequacy decision connected to the current agreement, which will come, so it's expected to come within the next 4 to 6 months. This will already indicate if the UK data protection standards are enough. A suggestion is to conclude this adequacy decision during the coming months in close dialogue with the UK, especially if their data protection scheme is deemed inadequate, to ensure the possibility to adapt accordingly. To incentivize possible necessary revisions, the EU should open up for the possibility of direct data access by initiating the negotiations on a new agreement within the coming months, more specifically an agreement that would aim to allow for direct data access. Thereafter, the parties should agree to the extent of the adequate levels required for an agreement allowing direct access to Europol databases, including EIS, as well as dispute resolution mechanisms. This is where the agreement will differ from the use of standard adequacy decisions. To enhance the certainty of uninterrupted free data flows and access, the agreement should in fact include higher data protection standards than EU law specifies. If the UK would infringe the terms of the agreement and not keep the data protection standards necessary, an arbitration court will have been established to resolve the dispute. If they see that the UK has broken the terms of the agreement, the UK should be given up to 6 months to revise their policies where necessary. This procedure would give more certainty that data flows can continue within the specified time, as the standards would be higher than the EU requires by law. In addition to data access, the parties should also include extended involvement in Europol as part of the agreement, such as invitation to the management board to ensure a continued central role of the UK in the agency. The UK should, however, be prepared, we think, to contribute financially to the agency with this privileged position. Conversely, if the UK opposes to a solid financial contribution, it would lose such privileges, meaning that its involvement would be reduced to the one included in the current agreement. Indeed, we really believe and hope to see the future cooperation with Europol, that the future cooperation with Europol will not be caught up in political disputes, but will concentrate on enhancing crime fighting capabilities as much as it can be done given the constraints posed by Brexit. And most importantly, that with this kind of compromise, the parties will hopefully be prepared to move on standpoints where they previously would have not moved. So overall, certainly there will be a lot to do, a lot to agree upon, but we think that there are the right premises for a more ambitious agreement, namely along the lines of a hybrid agreement, like the one we propose in our research paper. We also think that the political will is not lacking from both sides, especially in an area where there is a lot to benefit from, and we argue not so much to lose compared to other areas of the trade and cooperation agreement. So thank you very much for listening. I now open the floor to questions. If you could write them in the Q&A box, that'd be great. Thanks. Okay, I see already a few questions. So I'm just going to read the first one. Under the newly reached agreement, how do you expect the UK's commitment to European defence and security to diminish and its focus to shift to its own national defence and security? Okay, that's interesting. So, okay, I don't think that I don't think that this is going to be the case. So I don't think that the UK will diminish its commitment to European security, defense and security, simply because it's not directly, I think Brexit doesn't directly impact the role that the UK has in the broader European defense and security arena, which is associated more often to NATO rather than the EU. It is likely that the UK will maintain, I think, its defense capabilities and ability to project military power in Europe and within NATO. Because indeed, the UK is the 5th largest defense spender in the world, and it is actually currently implementing a program called Joint Force 2025, GF 2025, which involves the development of maritime, land, and air capabilities as part of its national security strategy, which I think will continue despite, Brexit will not affect this program, and this program is committed to European, a broader, so not just a strict UK defense and security policy, but a broader European security policy within NATO. And so I think that also throughout the discussion that we just had, it became clear that EU-UK cooperation matters hugely for the UK's national security as well. So it's not just it's not just that the EU would benefit from a cooperation with the UK, but it's also the other way around. So I think that the UK, in the short term at least, will not diminish its efforts. At the same time, so I was reading a RAND report recently, and it was raising the question of financial constraints that might arise due to the predicted economic uncertainty following Brexit. So this could be one problem, and indeed, even for example, the pandemic also doesn't help for sure in this sense. Also, the UK has been already reducing its personnel, so the UK's armed forces, as well as defense civil servants, have been heavily reduced in recent years. So Brexit might deepen this trend. So economic downturn might deepen this trend. Some analysts argue. Again, the pandemic, so the pandemic doesn't help either in this sense. And I guess, though, in this case, it's interesting, like another question or point that comes to my mind related to this question is asking the reverse. So will the EU, without the UK, increase or decrease its commitment to European security and defense, simply because the UK was the member state that was opposing the most to a European, for example, this idea of a European army and to increasing EU defense spending. So it will be interesting to see whether this idea, this ambition of stronger collective EU defense capabilities is going to be reinforced by Brexit or not. So a lot to think about, I guess. So another question. So how would a hybrid model be compatible with the different data protection regimes? Yes, so, okay, I haven't, there wasn't much time to delve into the legal details during the presentation, so I can expand a bit more now. So first of all, it is important to know that as part of the new trade deal, so the TCA, the EU has agreed to delay data transfer restrictions for at least another 4 to 6 months. So 4 months for now, and it can be extended to 6 months. This period has been called the bridge, a term that I really like, actually. So in this sense, so this means that personal data flow is still flowing, so at least for these 4 to 6 months, from the EU to the UK until, so at the end, what happens then at the end of the 6 months? So either, as I mentioned in the presentation, an adequacy decision is adopted, and the UK is already expecting, so one, to be adopted by the European Commission, but this is not necessarily, doesn't have to be the case. So it could also be that this bridge ends without any adequacy decision, which would be unfortunate. And another important point is that in terms of the European regulation that applies when talking about data flows is the EU GDPR, which I'm sure everybody knows. So this does no longer apply to the UK because it's a EU regulation. However, the UK compliance with UK data protection law is required, and UK data protection law has integrated the GDPR in its law. So formally the GDPR doesn't apply to the UK anymore, but because it has been integrated as part of the UK Data Protection Act, formally the difference is, so there is not much difference between the two different type of data regulations in place. And this indeed raises hopes for an adequacy decision to be issued by the EU to the UK, precisely because the regulation in this area is not that much different. The real problem, which is also the problem with which we are confronted when talking about intelligence sharing, is the flow of information from the EU to the UK, which is restricted by GDPR. So unless the EU Commission makes an adequacy decision, restrictions and safeguards to data flows will apply, which means that data from the EU to the UK, will not be able to flow. And so to actually go back to the original question, so the way that the hybrid model we propose is compatible with data flows under GDPR regulation is, precisely through this adequacy decision that we hope to see issued, again, by the European Commission very soon. So this adequacy decision, this means that if there is this decision, the UK is not treated like a third country like it is treated now, but it is, it means that it's safe for EU-UK data to continue to flow like before, basically. And but as mentioned in the presentation, in the field of cybercrime and intelligence sharing, we think that the restriction should be so that the agreement should, be based on this adequacy decision, but that there should be tighter regulation, precisely because we're dealing with sensible information, and so this is not going to be enough in this area. So there should be a stricter agreement in place and stricter regulation and controls in place that should be then agreed between the two parties. I hope this is clear. So then let's see. Okay, so do you think that the UK will be willing to financially contribute to Europol in exchange of a privileged position like the one they would have with a hybrid agreement? Okay, so I think that this question is related to the fact that, so that we argue in our research proposal that in addition to data access, the hybrid agreement should include extended UK involvement in Europol, such as, again, the inclusion in Europol's management board, and that the UK should be prepared to contribute financially to the agency in return for this privileged position. And the question is, do you think whether that's feasible or not? Yeah, that's actually a good point. Let's say that this would be, I think, the icing on the cake, in the sense that, I think everyone in this virtual room would love to see as much cooperation as possible between the EU and the UK. But I am aware that this might be asking a bit too much. At the same time, we think that being part of Europol's management board would be a pretty advantageous offer for the UK, and a trade deal is a trade deal. So the EU would ask something in exchange, and that's fair, I think. So now whether the UK thinks that, will think that the trade-off is worth it, it depends on many things. I agree. And, including, again, the economic situation in which the country will find itself, or already finds itself, after the pandemic, and once the effects of Brexit become clearer. Let's see. Okay, so there is already a TCA. Okay, this is more a comment rather than a question. There is already a TCA supporting agreement on the circulation of classified information signed contemporary to the TCA. Hence, most of the procedures and controls you suggest are already agreed. Okay, fair point. Yeah, fair point. I mean, I think that's a fair point. I think the problem would be that not the problem, or guess what we are also arguing in our option of this hybrid model is again like even further cooperation. So again, the UK joining the management board and other rules that are closer to the role that he had previous to Brexit. So yeah, and we do think that actually that again, this data protection issue is a matter of time. So it is a matter of time before an adequacy decision will be signed by the European, proposed by the European Commission, we think, at least. Because again, there's not much difference between the GDPR and UK regulation in this area. Okay. So, okay, I don't see any more questions. I'd say if there are no more questions, yeah, we can close it up.
Okay, thank you so much for your participation and for your interesting questions. We wanted to remind you that you have the opportunity of giving us feedback and telling us what you thought about this presentation. A poll will automatically a poll will be redirected to you where you can offer the feedback.
All right, thank you so much.
Yeah, and don't forget to join us for our next session. If you haven't registered for the EU competition policy post-Brexit, that you can still do that. The link is in the chat, so we would very much encourage you to do so. Our colleagues have prepared at least equally interesting and exciting presentations, so please go ahead and check that out. Thank you so much, and thank you for participating.
Thank you.